Hello everyone, this is Abhilasha Sharma and you are watching Judicial Opinion. Today we are going to cover Third School of Jurisprudence and the name of thy school is Natural School of Jurisprudence. So before we start with the Natural School of Jurisprudence, let's do a little bit of revision and let's recall all the schools of jurisprudence. The first school of jurisprudence is Analytical School. Second one is Historical School. Third one is Natural School. Fourth one is Sociological School. And today we are going to cover Natural School. Let's take note of all the four schools of jurisprudence as we have done. But before we start, let's discuss one thing, that when it is about jurisprudence, we have to find the source that gives power of enforceability. So what is important in jurisprudence is source. What is the source that is giving power of enforceability, and to whom they are giving power? They are giving power to laws. So the important question in jurisprudence is, that is, who is giving birth to the concerned law? Who is the source? When we are talking about birth, we are talking about who is the source of the concerned law, and here the concerned law is natural law. Before we go to natural law, let's talk about source. So the main question is, what is source? You have to be clear about source. The moment you are clear about source, you will be clear about everything when it comes to jurisprudence, because source is very much repeated in each concept. Even when we are going to go to all the other schools, the source is something that we are going to talk a lot about. Can you think of any example of source? Source that is giving power of enforceability to any law. Example of source. Yeah. Tick tick 1. Tick tick 2. Yeah. If any of you is thinking constitution, you are very much correct. Constitution of any country, all those countries who are having constitution as a source are very much right. Why it is a source? It is a source as it gives legitimacy. Legitimacy is power of being lawful to all the laws it contains. Let's talk about analytical school, as we are doing a little bit of revision so that we can understand source better. When we talk about source for analytical school, these are the jurists of the analytical school. This is John Austin, this is essentially Kurt. Sovereign and state. The modern jurists considered state is as the source of laws, and the older ones considered sovereign as the source for law. Now let's go to historical school. In historical school, society and culture were considered as sources. So what exactly is happening here is, if you are still not understanding the relationship, consider the relationship of a parent and a child. So child are the law and parent is the source. Okay, so now if you have understood the whole concept of source, what exactly source is and how exactly laws are coming from the source and getting their legitimacy, getting the power of enforceability, let's go to the main question that we have going to hear is, what is the source for natural law? Think. What can be the source for natural law? I'm going to again do the tick tick 1, tick tick 2, tick tick 3, tick tick 4. Yeah, tick tick 5. Yeah, many of you have guessed it correct. Nature can be the one. God can be the one. Divine law, universal morality. Yes, most of you guys are correct. So when it comes to source, God, universal morality, and also divine law is another source that jurists of this natural law have considered. But now, natural law, as many of you must have known, is also known as philosophical law. Why exactly it is called philosophical law? Because you have to decode, you have to understand, you have to reason, you have to comprehend natural law. So to decode, to reason, and to comprehend. As you have to do all these three things, natural school is also called as philosophical school of jurisprudence. But all the natural laws has to pass a test. They have to pass a test of reason, and in this reason there comes three things. One is just. All the laws has to be just to everybody. All the laws have to be fair to everybody, and they have to stand all the criticism and demand of time. All the natural law has a permanent nature to them. Let's take some examples of natural law. First example is age till one is considered to be a child. You are not going to be confused between a 6-month-old and a 60 years old guy. You know, if a 60-year-old guy is standing in front of you, he is probably old, and if a 6-month child is in front of you, you are going to know that that particular child is an infant. So you are going to know what age every person is, and we know how age is happening because of natural law. Then age when one is considered to become an adult biologically. So in Nirbhaya rape case, was one question because of one particular accused and alleged person who was convicted after the trial, and he was convicted, but during the trial the question was whether he should be tried as a juvenile or whether he should be tried as an adult because of the rarity of the heinous crime he committed. Now another thing is days earth take to complete a revolution. We know how age is happening, how when age till one is considered to be a child or the age when one considered to become an adult biologically. We know both of these things because we know how many days earth take to complete a revolution. Another thing is when we talk about natural law, we talk about inbuilt moral compass among all humans, among the humanity. So what exactly the example here is the inbuilt moral compass that tells us when we are respected or when the behavior of the second party is defamatory. So when we are respected or when we are defamed, we get to know because of the inbuilt moral compass that we have in all ourselves. Let's talk about over the time period natural school was built and propounded by its jurists. So now we are going to discuss jurists of the natural school. This guy is Heraclitus and he is amazing. His key concept was logos, universal reason. He was the one who started in 535 BC. This was the year he was born and this was the year he died, and during this time period he coined this term logos, and he coined the thing that universal reason is something, and he said law is the will of the people. Law is the will of the people. He also talked something about the general will. He was the first one who also talked about the general will. But he said something very interesting, that behind every law something stand, and that what stand is logos. Logic stand. Logos is universal reason. What he meant by it is law is rooted in universal reason governing nature and human conduct. So you cannot divorce nature or human conduct from universal reason. If something is law and it is going to govern nature or human conduct, it is going to have universal reason in it. Okay. Another one is again an amazing guy. I'm saying amazing guy, so you are going to have his picture in your mind while writing your answers. This is his face. He was born in 469 BC and he died in 399 BC. His contribution to natural law was moral foundation of law. His core idea was law must serve justice and virtue, not power obedience to law is moral only if law is just. So justice and virtue is something that he coined, and another thing he coined is only. So Socrates never wrote a single thing in his whole life, but his student Plato. Plato wrote Crito and Apology. And in Crito and Apology, after reading these two documents, you are going to know that these were Socrates' ideas, that law must serve justice and virtue, not power, and obedience to law is moral only if law is just. So, I mean, just imagine what kind of question it must have been, that it must had been that in front, especially in front of Socrates, that he had to say something like this, that obedience to law is moral. Like he is saying, okay, if you're going to surrender something, if you're surrendering your power, as we are going to know in read in social contract theory, that people come together and they surrender their power, that is something moral in nature. But if it is only moral if law is just, if the law in front of you is not just, then it is not moral thing you're doing something immoral, right? And law, what exactly law has to have in their agenda? Law has to have the one single thing in their agenda, that it has to serve justice and virtue. If it is not serving justice and virtue, it is serving power. And if it is serving power, that kind of a law is going to be unjust law. And to that particular kind of unjust law, there has to be no obedience. Because that kind of obedience is going to be immoral obedience, not a moral obedience. Right. So that's an amazing thing that he said, an amazing thing for us to learn from him. I mean, these guys are all great. These 13, 14 jurists are all great jurists, and we are going to learn a lot from them. His teaching was, it is better to suffer injustice than to commit injustice. And something you should know about Socrates as a teacher, that he taught critical thinking to his own student, and he was killed. He was poisoned by his own people for teaching critical thinking. Socrates had a very firm belief that there is only one God. He stopped believing in Athene's God and he started believing that there is only one God. There are not 30, 40, 50 or 100 gods, but only one God is there. And from that one God you have to derive all your laws. And all those laws that are going to be derived, who are going to be driven from your one God, they are going to be completely just in nature. So that was his firm belief. And I am going to say that it was a fact. Okay. So guys, let's go to another jurist. Another one, you should guess his name. We just talked about him. What do you think of him? Who is he? Handsome guy. His name is Plato, and he gave ideal forms and justice. His core idea was, law should reflect ideal justice, not popular opinion. The government could be a populace, but the government has to create some sort of laws that reflect ideal justice. The government cannot just go after pleasing a popular opinion of the people. Okay, because bad laws come from ignorance, not reason. If you're going to base your law in reason, then you're going to get good laws. But if you're going to base your laws in ignorance, then you're going to get bad laws. I just read about Shabana case, and the movie has come. What is the name of the movie? The name of the movie, I believe, is Huck. And if you're going to watch that movie, you're going to see that people have been very ignorant while they created laws for Muslim women. They did not see that a Muslim woman is going to need the iddat period to last for a long period of time, or she is going to need alimony. They just did not see the need of an alimony, especially for older women. If you're going to get a divorce in your old age, you're going to have the need of an alimony. You cannot survive because you cannot just go and get a job, because in old age it's very hard to get a job, and if you get a divorce in our old age, you're going to need an alimony, especially if you're going to have your kids with you. So that was ignorance on their part. And another case that I was reading recently also told me something about ignorance. So that's there. You are going to read a lot of cases and you're going to learn a lot about ignorance. So Plato is known for his theory of forms. Plato's theory of form is based on the idea that there are two distinct realms of existence. The world of form is one of the realms of existence, and another realm of existence is the world of appearances. The world of form is the realm of reality which is eternal, unchanging, and perfect. It is the realm of abstract entities such as beauty, justice, goodness, and truth. The world of appearance, on the other hand, is the realm of sensory experiences, which is temporal, changing, and imperfect. So, it is the realm of physical objects such as trees, tables, and chairs. According to Plato, the physical world that we perceive is mere copy of imitation of the world of forms. The physical objects that we see are imperfect copies of the ideal forms that exist in the world of forms. For example, a particular apple is an imperfect copy of the ideal form of apple which exist in the world of forms. The ideal form of apple is eternal, unchanging, and perfect, whereas the physical apple is temporal, changing, and imperfect. So, this is something he believed that, yes, of course, we don't believe in his ideas. I mean, a lot of people will not believe, but it's some sort of philosophy is there, it's some sort of hypothesis is there that there is some sort of ideal world that could exist, and if we are going to talk about in that particular ideal world, the beauty is not going to degrade, the beauty of apple is going to remain as it is. So that was the belief of Plato, that there is the world of appearance in which a beauty degrades with time, but if we are going to talk about an utopia, the beauty will not degrade with time. That was his belief. I'm not going to say that it was a fact. Who is this person? Tell me. Who is this? Come on, guys. We all know him. He's very famous. He is Aristotle. Ladies and gentlemen, I present you Aristotle now. So, Aristotle drew a very good distinction between natural justice and legal justice. So, what is legal justice? What is natural justice? So, when we talk about natural justice, for example, if God is going to judge your case, He is going to judge your case in such a manner that He is going to give you natural justice. The justice is not going to be man made, it is not going to deflect in any way. But if you are going to be judged by a human, that human is not going to be perfect. The judgment is not going to be perfect. The judgment is going to be somewhere imperfect. That was the belief of Aristotle. Natural law is that which everywhere has the same force and does not exist by people's thinking this or that. Distinguish natural law unchanging from positive law man-made. So that was his belief, that when we talk about natural law, it is going to remain the same, but that is not going to be the case when we talk about man-made law, which is the legal justice. Let's take this from an example. Okay, so this is age till one is considered to be a child. It's a natural law. It is never going to change for anybody. If you talk about an American or if you talk about an Indian, we both are going to see the same 6 months old as a baby, but we both are going to see the 60-year-old guy as an old age guy, not as a baby. But when we talk about age when one is considered to be an adult, leave biologically, but when we to talk about somebody when they are going to become an adult, for example, we are going to talk about marriage. then in a marriage, especially in India, it is considered that a woman is able mentally prepared for marriage when she is 18 years old. But when we talk about guys, it is considered that they are going to be mentally prepared for marriage when they are going to be turned 21. So we have different ideas for men and women, and it is completely fine that we have different kind of ideas for men and women when it comes to marriage. Now let's talk about Cicero. Cicero had the very right thinking when it comes to laws. He believed in right reason and he believed in true law. His saying was, true law is right reason in agreement with nature. It is of universal application, unchanging and everlasting. So when we are going to talk about natural law, we are going to talk about three things a lot. That natural laws have the universal application and they are unchanging and they are everlasting. Because I already told you that as I already told you that the natural law have a permanent nature to them. So because of this permanent nature, they are everlasting, they are unchanging, and you can bet on them with your life that they are not going to change. Okay, so law does not depend on the state. Unjust law are not laws at all. This was the belief of Cicero. I think this was clear with you guys. Let's go to another jurist. And this is St. Augustine. So what exactly St. Augustine believed? St. Augustine believed in the divine law above human law. An unjust law is not law at all. Human law must conform to God's to be valid. Okay, so St. Augustine believed that human law comes below and divine law are above. They are having a little bit of superlative degree here, divine law, but when we talk about human law, they don't have that particular stage. They are not par with the divine law. They come somewhere below them. Okay, so unjust law is not law at all. Everybody was saying it, but they were not saying it very clearly. But when we talk about St. Augustine, he came with force and he said it that you know what, an unjust law is not law at all. And he believed that all the divine law are just law and they have to be considered laws. Let's go to another jurist. Another jurist is St. Thomas Aquinas. He is our 12th century jurist. So for a very long time period, nobody believed in natural law and natural law school was somewhere forgotten. But St. Aquinas came up and he came up with four law theory. He said, you know what, we can classify law in four parts: eternal law, divine law, natural law and human law. So human law you understand, natural law you understand, and he said natural law and divine law are a little bit different, and then there is an eternal law. Eternal law is for everybody, but divine law is something which is written in Bible, and to have that Bible to decode you need us saints. Okay, you need fathers and you need complete their own charades. I'm going to say a word, it's not a derogatory word, please do not consider it like that, but yeah, so you need their whole charades to understand divine law. Divine law is something that you won't be able to understand on your own. That was his belief, that was his, everybody is going to say, game plan to put church right with kings. Okay, now what exactly he said? He said law is an ordinance of reason for the common good made by him who has the care of the community. Natural law comes from human participation in divine reason. I mean, just imagine the kind of thinking he must have done. And he was the one who again propounded natural law theory back into the game in the 12th century. So for a very long time period, we did not have any jurist who was saying something in favor of natural jurisprudence. Now this is Hugo Grotius, and Hugo Grotius believed in secular natural law. He had a very different idea and he came in the 15th century, and he said natural law would exist even if God did not exist. He believed natural law based on human reason, not theology, father of international law. So you must have understood what he is saying. Natural law would exist even if God did not exist. What, I mean, it's very revolutionary idea, but till this date till this time we have been talking that the God is the one who has given the natural law. Even Socrates believe in this one, but he is going back to the Heraclitus idea that, you know what, he directly put it like that: law is the will of the people, but behind it stands the logos. So universal reason, like Heraclitus did not believe that law is coming, the natural law is going to come from the god, but he did believe that, it is going to come from the universal reason, it is going to come from the logos, it is going to be, law is definitely going to come from the people, but behind it, it's always going to be the universal reason is going to stand, that the law is going to be rooted in universal reason. And the same thing Hugo believes, the father of international law, believed the same thing. So it's amazing that, it's keep on repeating, the concepts are going to keep on repeating, and each one of them are going to say something that the other one has already said. So Hugo Grotius is another amazing guy, and this is something you're going to learn from him, that it is secular. So even if you're an atheist and you do not believe in the concept of God, you are going to believe in the concept of natural law. And this is something I believe Bhagat Singh has also said, that, you know what, I don't believe in God, but I do believe in the concept of natural law, that there is some sort of thing as natural justice, and it will happen. So we are at the same place with him. We also believe that even if we deny that existence of God, we cannot deny the existence of natural law. Natural law are going to exist even if God is not going to exist. Now let's talk of Thomas Hobbes. Yes, gentlemen, I present you Thomas Hobbes. Thomas Hobbes is another 15th century guy, another stand-up guy, amazing personality, and he believed law of nature for self-preservation. Self-preservation. How exactly he believed that? The right of nature is the liberty each man hath to preserve his own life. Natural law promote peace and survival enforced through sovereign power. Just imagine. Okay, so we have to talk about John Locke. Without John Locke, we cannot talk about him. Yes, let's talk about John Locke. So, John Locke believed that man is born with the title to perfect freedom and enjoyment of all the right of nature. He believed that we have three natural rights, and these three rights come with us the moment we are born. And these three rights are life. We have the right to life. We have the right to liberty. We have the right to property. And if you want to challenge me, I will say we have the right to dignity. And these three rights comes the moment a man is born. And this is something Thomas Hobbes also believed, and because of that reason he said that the law of nature are for self-preservation, that you have the right to preserve these rights. These three rights are bestowed in all ourselves, and in they are just our fundamental right that a man comes with in this world, and you cannot take away these rights. A man cannot do without these rights. The right of nature is the liberty each man hath to preserve his own life. Amazing guys, these guys are just amazing. And keep on reading. So John Locke we have discussed, Thomas Hobbes and discussed, and let's discuss Rousseau. Ladies and gentlemen, I present you Rousseau. Rousseau is now here for batting or bowling, who knows. And Rousseau's come with general will concept. Okay, ladies and gentlemen, we have the concept of general will. Who is going to bet on this concept? Who knows? But this is another amazing concept and something that I firmly believe in. Man is born free and everywhere he is in chains. What a line. What a line, sir. What a line. Law should express the general will rooted in natural freedom. General will is something that has to be expressed. People have to come together and they have to agree upon something. And when people come together and they agree heinous crimes like child marriages do not happen, because then people agree, okay, this is not the right age for people to get married, let's just not do, because then we are promoting rapes. Marital rapes is promoted because they are a result of child marriages. Once you are committing something as child marriage, which is a crime, which should be considered as a crime, and should not be a result of general will. Let's go to another jurist. Another jurist is Immanuel Kant. His key concept was moral law and categorical imperative. He said, act only according to the maxim, whereby you can will that it should become a universal law. Law must conform to moral autonomy and reason. Again, an amazing thing, but he is repeating the same thing. I'm giving you time to read. Come on, just read it once. Act only according to the maxim, yes, whereby you can will that it should become a universal law. So when you are creating a law, you should be have this thing in mind. Okay, this law should have the potential to become a universal law. I'm not creating a law for only majority, or I'm not creating a law only for minority. I'm creating a law for everybody. So general will and individual will both have to come on the same power, and I have to create a law which is going to suit both of them. It has to suit minority as well as majority. That is something you have to consider while you're creating law, and then only when you are considering something like this, you put natural justice, principle of natural justice in the play. Now let's talk about Johann Fichte. I'm not going to say Gottlieb. I'm confused about the pronunciation. He is talking about freedom and moral will. His core ideas was law exists to secure freedom. Individual must coexist with others' freedom. We all know freedom is something which is a subjective idea. We do believe that every human is coming to this life with this particular idea that that my born right is that I am going to have the full freedom. But when we come into the society, we got to know, okay, the right of freedom is subjective. You are not going to have a full freedom. So individual will must coexist with others' freedom. So that what she is saying is that individual will has to coexist with general will as well. Both the wills have to coexist with each other. The source in which he wrote such things is Foundation of Natural Right, 1796. Please do remember this book or document of him. Key ideas. Law is necessary so that freedom does not destroy itself. Law is necessary so that freedom does not destroy itself. Just amazing. I mean, you are given the freedom. Now you have the freedom, but what you are going to do? You have to have some sort of foundation, because absolute freedom can corrupt you absolutely, right? Let's go to another jurist, and this time I present you George Wilhelm Friedrich Hegel. Today we are going to talk about Hegel, guys. Hegel is another 17th century guy, and he was alive in 18th century as well. So you can say he was 17th to 18th century guy. He did not live much, but he is again another stand-up guy. Ethical state and historical reason was his key concept. His core idea is law evolves through history. The state represents ethical reason in action. Okay, so he did believe in natural law, but when you are going to read his theory, you are going to say that his theory, somewhere get amalgamates with the theory of analytical school and historical school as well. But he is right, he is not wrong. When he say law evolves through history, law does evolve through history, and law and the state represent ethical reason in action. It does. His famous idea was what is rational is real, and what is real is rational. Just imagine. What is rational is real and what is real is rational. Hegel historicizes natural law. Law is reason unfolding over time. I'm repeating, I mean, we are repeating just him. But yeah. And his book is Philosophy of Right. He was very much right, guys. Please do remember him. And another modern jurist we have here is Lon L. Fuller. Modern natural law ki jurist he was. Lon L. Fuller, his key concept was inner morality of law, and his eight principle was general publicity, clarity, and non-retroactivity. His famous saying was, "Law is the enterprise of subjecting human conduct to the governance of rules, and procedural morality is essential for legal validity." These are some really fine words, guys, really fine words, but let's just go to his eight principle. His first principle was law must be relatively stable. His second principle was official action must be consistent with declared rules. His third principle is law must be clear. His fourth principle was law must not be contradictory. His fifth principle was law must be prospective, not retrospective. Law should be always about what is going to happen ahead. It should not go back and redo the things again and again, again and again. There's no point of it. Law must be promulgated and published. That is something we all know. Right to information only comes from this right. If law is not going to be published, it is going to be very confusing, because we are not going to know about what law is going to be enforceable and what laws are not enforceable. The confusion is always going to be there. So his one of the principle was law has to be published at any given point. The moment you have created a law, please do publish it. Law must not demand the impossible. That was his saying. Please do not demand impossible from the people. And law must be general. That was his another saying. So these are the eight principles that he coined, and they go very much in his with his saying that law has to follow these eight principles. Only then morality of law is going to come into the picture. Otherwise, immoral laws or unjust laws are going to promulgate in the society. Violate these and you don't have bad law, you have no law at all. He again believed in the concept that there is a just law or there is no law at all, because if there is a law, it has to be just and it has to follow the concept of natural law. Now let's talk about the hero of the hour. Everybody is hero. I mean, all the jurists are just amazing, but I am a huge fan of P.N. Bhagwati, so we are going to talk about P.N. Bhagwati. So P.N. Bhagwati's contribution was judicial activism and PIL, and he said a lot of amazing things, but he did a lot of amazing things. And the cases that he did, we are going to read a lot about their cases. So let's just start with the cases that he did. Landmark cases where Justice P.N. Bhagwati articulated the human and moral face of the law. Menaka Gandhi case. In Menaka Gandhi cases, the due process was followed. His exact quote, or what P.N. Bhagwati exactly said, was that procedure established by law must be right, just, and fair. Guys, just and fair. Where exactly we talked about it? Earlier we talked about just and fair. Let's just go back to that slide of ours where we talked about just and fair. We actually studied a lot today. Just and fair. A natural law has to stand, a law has to stand just and fair. But where P.N. Bhagwati is saying and talking about, he is talking about the procedure as well. So if you are going to have a procedure, if a law has laid down a procedure, that particular procedure also has to be just and fair. Procedures cannot be unjust or unfair or unreasonable. Okay, guys? So this was Menka Gandhi versus Union of India. Husainara Khatun versus State of Bihar. The right to a speedy trial is an essential ingredient of a reasonable, fair, and just procedure. Again, so this was a statement made by P.N. Bhagwati sir in the Husainara Khatun versus State of Bihar case. In this particular case, he is saying something very interesting. He is saying that the right to speedy trial is an essential ingredient of what? Ingredient of reasonable, fair, and just procedure. So till this date we were just talking about fair and just and reasonable laws. We were not talking about the procedure that is laid down by these laws. But now P.N. Bhagwati sir started focusing on the procedure as well. So how does it link with natural law? It links as delays itself is injustice. Justice must be timely to be moral. The delayed justice is no justice not done to anybody, right? So this was his statement, and this strongly aligns with Lon L. Fuller's principle that law must not demand the impossible. When you are started to delay, when you keep on delaying a justice to somebody, you are asking them to do something completely impossible. You cannot wait till your death for justice to happen to you. You want the justice to happen to you right away, if that's possible. Or you can only wait to a time period which is right for you or right for the case. You cannot wait till your death. That's just impossible thing. But that's what unfortunately Indian judiciary has been asking to all those people who have been filing the cases and to all those people who have been litigating. People die and their lawyers die, but the case just never ends. It keeps on going. You just don't get justice until unless you're dead. It's just an unfortunate scenario of our Indian judiciary system. But yeah, P.N. Bhagwati saw that thing and he raised questions against it. Bandhao Mukti Morcha versus Union of India. That's another case, and his exact quote in that particular case is, "The Constitution is not a mere lawyer's document, it's a vehicle of life." So, what he is converting Constitution into something that nobody has ever thought of. He is converting Constitution into a moral document. So, why this matters? Court steps beyond adversarial boundaries, protects those without access to justice. And the human link is, in the natural law link is that the human dignity exists prior to legal recognition, and constitutional merely recognizes moral rights. So these are the things that he recognized, those things, and he highlighted those things, and this is why P.N. Bhagwati is such an important jurist of Natural School of Law. His fourth case is S.P. Gupta versus Union of India, and he said any member of the public acting bona fide can invoke the judicial process for redressal of public injury. I mean, just imagine at that particular time, he laid down the PIL doctrine that even if you are not a member of a case, but if those people are not able or not willing to raise their voices for themselves, and you are a member of this public and you think that you want to raise and invoke judicial process, then you can do it. I mean, just imagine, he did an amazing job, amazing guy. People's Union for Democratic Right versus Union of India. That was aside workers case. A lot of cases are there. Please remember this case name. And he said non-payment of minimum wages is forced labor. So if you are not paying, you are making a person to work at lesser than minimum wage, then what exactly you are doing? You are doing bandhua majduri, right? Bandhua majduri is forced labor. Natural lawing exploitation is immoral even if contractually masked, right? Even if you have masked it contractually, even in that particular case, even if you are doing exploitation, it is immoral, and that particular law is unjust, and justice examines substance, not form. So I hope this case is also clear in your head that the non-payment of minimum wages is forced labor, bandhwa majduri. Olga Tellis versus Bombay Municipal Corporation 1985. The right to life includes the right to livelihood. So basically what he did, he expanded right to life, which is given in Article 21, and he expanded it and he inculcated right to livelihood in the same article. So now when you're going to read it, the article contains a lot of precedents given by the Supreme Court as well as High Court. Values Justice P.N. Bhagwati held throughout his career, which makes him a natural school jurist. Constitution as a moral text. For P.N. Bhagwati, Constitution is not value neutral, it embodies justice, equality, dignity. So yes, he considered Constitution as a moral text, and natural law school believes that the law has moral content in it. So yes, as natural school law is a very big on morality, as even we consider universal morality as a source for natural law. P.N. Bhagwati sir considering constitution as a moral document was a huge thing, and because of this particular reason he is considered to be a natural school law jurist. Right as inherent, not granted. P.N. Bhagwati treats liberty, dignity, livelihood as free constitutional mirrors Locke's natural right theory. Substantive justice over technicalities. He openly dismantled procedural barriers and locus standi restrictions. Judicial activism as moral duty. He considered judicial activism as moral duty of every jurist and every justice. So what exactly, when we are going to consider each and everything that P.N. Bhagwati sir did and all the things that man-made law does, that law is equal to command, law is equal to justice, procedural is supreme, fairness is supreme under P.N. Bhagwati sir, and natural is neutral is state is neutral, and he said that the constitution has a moral ground to it, and courts were considered to be closed under man-made law, but P.N. Bhagwati sir made courts open, and he even opened it to PILs. So what was the revolutionary move of P.N. Bhagwati sir that he laid in S.P. Gupta versus Union of India? He held that where a legal wrong or a legal injury is caused to a person or to a determinate class of persons by reason of violation of any constitutional or legal right, and such person or class of persons is unable to approach the court, any matter of public can maintain an application. So this is where he laid PIL as a doctrine, not as a sympathy based exception. Why this matter? It matters because it opened the courts to prisoners, it opened the courts to bonded laborers, it opened the courts to payment dwellers, it opened the courts to children, it opened the courts to women. All these people who are not able to have because of any reason XYZ, whatever the reason these guys have, they are not able to stand up for themselves, they are not able to go ahead and file a case in the court of law. So in those particular situation, if a third party is coming up and they are filing a case on their behalf, it's a good thing and it's a PIL move. He turns letter into writ petition. This was a radical move that it did, and it was a radical innovation. It was a master stroke, I believe. And P.N. Bhagwati sir allowed letters, postcards, and newspaper reports to be treated as writ petition. And the key case was Husainara Khatun versus State of Bihar. Under trial, prison didn't even know their rights. The court acted suo motu. Why this is activism? This is an activism because court abandons formalism, right? Because of this particular P.N. Bhagwati sir further expanded the Article 21 into a moral compass as well as moral universe. Before Menka Gandhi, 1978, Article 21 was considered like procedural established by law, meaning any procedure, however harsh, it has to be followed no matter what. But P.N. Bhagwati sir came up and he interpreted that procedure must be right, just, fair, not arbitrary, not fanciful, not oppressive, right? And because of this particular reason, he was able to expand Article 21 to include right to livelihood, right to speedy trial, right to human dignity, and right to against custodial violence, right to shelters. He reimagined the constitution as a social justice document. Bhagwat P.N. Bhagwati sir considered constantly emphasized the constitution is not a mere lawyer's document, it is a vehicle of life. He introduced continuing mandamus. What is it? Court does not close the case, keep monitoring compliance over time. Bonded labor cases, environmental cases, prisoners reforms. In all these cases, court can keep monitoring these cases. So it is a continuing mandamus. And court became protectors of the marginalized, interpreters of the social reality. Fundamental rights were started to be read with directive principles. So prior to him, directive principles were kept in isolation. People were ignorant towards them. But he started keeping them in the highlight and he started reading directive principles along with the fundamental rights. While applying the fundamental rights, or while invoking the fundamental rights, he started invoking directive principles as well as a guiding principle towards where the judiciary has to move to enlighten the whole society. He gave judicial activism as a moral justification. P.N. Bhagwati sir did not see activism as an overreach. For him, judicial restraint in the face of injustice is abdication of duty. So he believed legislature may fail, executive may neglect, judiciary must act as a constitutional conscience. So in all those cases when legislature is going to fail, when executive is going to neglect, judiciary has to act as a constitutional conscience for the whole society. So this is a paragraph, this is something that you all should read and you should all keep in your copies or notebooks. Because you can write it when if it's modern jurists for Natural School of Law are going to be asked in your question papers. Let me read it for you. Justice P.N. Bhagwati is regarded as the architect of judicial activism and public interest litigation in India because he fundamentally transformed the role of the judiciary from a passive adjudicator to an active protector of constitutional morality. By liberalizing locus standi, converting letters into writ petition, expanding Article 21 into a guarantee of substantive due process, and interpreting the Constitution as a social justice document, Bhagwati institutionalized judicial intervention on behalf of the marginalized. His jurisprudence provided both doctrinal structure and moral justification to judicial activism, making it a permanent feature of Indian constitutional law. So this is him, and because of this particular paragraph, he is a great architect of judicial activism and public interest litigation in India. And because of this particular reason, you should consider him as a great jurist of Natural School of Law. Justice V.R. Krishna Iyer, 1915 to 2014, Humanist Jurisprudence and Natural Law Idea. His law idea was that law without compassion is tyranny, justice must be human, not mechanical. So, till this time period, we did not have the human touch to the jurisprudence of Natural School of Law, but V.R. Krishna Iyer sir came and he gave this a humanistic touch as well. His first case was Sunil Batra versus Delhi administration. In this particular case, he said the human touch of judicial compassion must temper the iron hand of law. So, iron hand of law, even when we are considering natural law, sometimes natural law can also be harsh, but it has to come with judicial compassion. The jurist or the justice has to be compassionate towards the another case that Krishna Iyer sir took was Menaka Gandhi versus Union of India. In this particular case, he said procedure is but a handmaiden of justice, not its mistress. Another case that he took was Muhammad Ghiasuddin versus State of Andhra Pradesh. In this particular case, he said every saint has a past and every sinner has a future. So, because every sinner has a future and every saint has a past, we should we should reject retributive justice and we should consider reformation, not vengeance. And it is linked with natural law because punishment must align with moral purposes and echoes Aristotle's idea of corrective justice. Another case that he took was State of Rajasthan versus Balchand in 1977. In this particular case, he said the basic rule may perhaps be tersely, but as bail, not put as bail, not jail. Okay. So, natural law link here is liberty is the default moral condition. A state must justify deprivation of freedom. Very close to Loki's natural right. Yeah, he is very close to Loki's natural right. Another case is Babu Singh versus State of Uttar Pradesh. In this particular case, he said personal liberty deprived when bail is refused is too precious a value of our constitutional system recognized under Article 21. Yes, he because liberty is not a state gift; it is a natural right. Right? You are not going to say that liberty is a state gift, and court must protect it as a moral right. Another case that he took was Prem Shankar Shukla versus State versus Delhi administration 1980. In this particular case, he said handcuffing is a prima facie inhuman and unreasonable and therefore unconstitutional. Every even administrative convenience cannot defeat human dignity. Dignity is treated as natural, inherent, and inviolable. This is a paragraph that you should consider for Justice V.R. Krishna Iyer that represents his Indian embodiment of natural law tradition. His jurisprudence consistently placed human dignity, compassion, liberty, and moral conscience above mechanical legality by treating rights as inherent rather than state conferred, insisting that punishment be reformative, and reading the Constitution as a moral document. Krishna Iyer carried forward the legacy of Cicero, Aquinas, Kant, and Fuller into Indian constitutional law. His judgment reminds us the law divorced from humanity ceases to be justice. Let me just repeat this last line. His judgments reminds us that law divorced from humanity ceases to be justice. How Krishna Iyer advances natural law. This is something that you guys must read and must consider. Please do follow all these slides that are further reading. Law must obey morality. That is something that you should also consider, that the law has to follow morality. Court must test them against human dignity, fairness, and compassion. So compassion is another point that he put forward when it comes to natural law. Prior to this, natural law never talked about compassion or human dignity. It did talk about fairness, but it never talked about compassion. But when we talk about Krishna Iyer sir, we are going to talk about compassion and human dignity and humanity. Human dignity as the core of law. This is another thing that he emphasized on, that dignity is not a guarantee or by the constitution. The constitution merely recognizes dignity is something, right to dignity is something that comes prior, and it is a birthright. Compassion as a legal value. He openly rejects cold formalism. Courts are not cold storage room of legal logic. That's what he said, and he kept on emphasizing it. Substantive justice over mechanical justice. Procedure must serve justice, technical legality must yield to moral fairness. That's all from our side, guys. This is Judicial Opinion, and I am your host, Abhilasha Sharma. And if you want something new next time, please let us know. We will cover another topic in very detail. And please do subscribe us. And if you want to know more about us, please go to our Instagram account and you will find us there. So that's all from our side, guys. Have a great day. See ya.